Greetings, guys, and welcome to chapter here on the courts, the judiciary. And I've posted a photograph of the Supreme Court justices, and when you get a chance, take a look at that and see if you can see if you know any of them, match up any of the names. With the photograph. If we were in class, I'd be showing that to you right now, but can't do that. What I'm going to do, though, is turn our attention to the lecture model and the objectives here for this particular chapter. We want to trace the development of the federal judiciary and the origins of judicial review. We're going to describe the structure and main components of the American legal system, explain the organization of the federal court system, and evaluate the Supreme Court's process for cases to hear. Some of the major heads-up terms here are going to be dwelling on will be judicial review. Judicial review is where it's the court's checks on the legislative branch and the executive branch to see if, what is, being legislated and carried out is indeed constitutional. The Judiciary Act of 1789. The Judiciary Act of 1789 basically was to set up a tiered court structure that we have today, a three-tiered court structure. Marbury versus Madison, watershed court case in 1789 as well. James Madison did not, I'm trying to explain this real quickly here because of time. James Madison was supposed to send out some certificates to some judges. John Adams, we talked about John Adams last chapter, very partisan guy, looked to, and he probably started political parties for all intents and purposes. On his way out, he was a Federalist, hated Jefferson. Jefferson was taking office. And John Adams looked to pack the court with federal justices, and he didn't get the certificates out in time, and Jefferson ended up in office and basically told his Secretary of State, James Madison, to accidentally on purpose not to get those certificates out to these prospective judges. And I went to court in the famous Marbury versus Madison case. Jurisdiction, we will talk about that at some length. That's, basically we'll talk about that several times. That's the right to hear a case. Original jurisdiction is basically where the court hears disputes and determines the facts. Court hears disputes, determines the facts. It's different from appellate jurisdiction. Appellate jurisdiction is basically where the courts review or reverse lower court hearings. Right, a little different from original jurisdiction. Then there's criminal law and civil law. Criminal law regulates individual conduct. Civil law is basically relations between private citizens. District courts, these are federal courts with original jurisdiction. They hear the facts, right? Original jurisdiction. They hear the facts of the case. They're not reviewing anything. Courts of appeals, we'll talk about that as well. They're basically circuit courts, and they review cases. They review cases that were, of original jurisdiction. The D.C. Circuit Court of Appeals, or the D.C. Court of Appeals, this basically deals with regulatory commissions. Then you have your Federal Court of Appeals, dealing with patents, contracts, claims against the government. Precedents, we've talked about that several times in the course already. We'll talk about a term called stare decisis, basically saying that you let the decision stand. Whatever the early precedent was, you basically leave it alone. You don't try to turn it over. Stare decisis, right? Let the decision stand. Concurring opinions, This is where the justice might agree with the verdict, but not the reasoning. And then per curiam opinion, unsigned opinion that is issued by the court. And then lastly, I didn't have this written down here on heads-up terms, judicial restraint and judicial activism. Judicial restraint is where judges should look to limit the exercise of their own power, and judicial activism, judges, the logic there is that judges should creatively interpret the text of the Constitution to serve the contemporary needs of society. Or another way to look at this, judicial restraint would be, you don't mess with what was written, in the late 1780s, right? The way the framers wrote it to begin with, right? More of strict constructionism. Judicial activism, you're kind of interpreting the Constitution in a living breathing document that changes over time. Let's take a look at this here, the roots of the federal judiciary, looking at your fills right off the bat here. Alexander Hamilton once called the national judiciary the, quote, least dangerous branch. The least dangerous branch, end quote. And as I say here, that was probably true in the late 1700s. But today the federal courts are significantly different and more powerful. And some of you guys are doing some papers on that. There's, a lot of debate today. Some people feel like the courts are maybe taking the place of Congress and, quote unquote, legislating from the bench. Nevertheless, the courts still have two basic limitations. They have neither the power of the purse nor the sword. They have neither the power of the purse nor the sword. In other words, the courts can rule on issues, but they cannot fund programs or their implementation. They also cannot force compliance with their rulings. For those things, they have to rely on Congress and the president, right, the executive branch. Let's say this too. I mean, I'll have this in the fills or the notes, but, it is true, I think, that most Americans do not know much about the judiciary. Like that photo I'm alerting you folks to. Most Americans probably don't know half of who the justices are. Most think it's an apolitical orbit, that they are not above the fray, but they're part of it. It could be highly argued. Let's take a look at some notes here. Article 3, right, dealing with the judiciary branch of the Constitution and what it establishes. And we'll go to the whiteboard. Article 3 of the Constitution establishes, first off, the Supreme Court, in which judicial power of the United States is vested. Life tenure, or good behavior for judges. Compensation that cannot be diminished during their service. Inferior courts, as Congress may choose to establish. And original jurisdiction of the Supreme Court. Again, original jurisdiction, you're hearing the facts of a case. We'll talk about this a little later, but most of what the Supreme Court does is review cases from lower courts, but they also have original jurisdiction. So as with the rest of the Constitution, Article 3 was the result of compromise. I mean, during the days of writing the Constitution, there were so many debates at the Constitutional Convention in Philadelphia, as some of you remember, between the Federalists and the Anti-Federalists during those ratification debates about the document, including Article 3. Among key issues that did not make it into the new document were no federal courts below the Supreme Court, explicitly giving the Supreme Court the power of judicial review, Again, judicial review is the power to review acts of other branches and rule them unconstitutional if need be. Limited terms for justices and more. So the limits, the checks and balances, if you will, placed on the courts were also, when you really get right down to it, compromise between those who feared the chaos under the Articles of Confederation and the excessive order of, under former British rule. Trying to find a balance, right? The Judiciary Act of 1789 and the creation of the federal judicial system, Congress established inferior courts. Congress established inferior courts through the Judiciary Act of 1789. And this act established a federal judiciary in the same three-tiered structure that we know today. The main courts of fact in the federal system are district courts. They are district courts. Then come the circuit courts of appeals. The circuit courts of appeals. And then finally, the Supreme Court. The Supreme Court. So the Judiciary Act also set the number of justices for the Supreme Court at 6 initially. And as I say here, that number's varied over the years, since it's not determined in the Constitution, surprisingly, right? It's generally has ranged from 5 to 10. It was set at 9 by the Judiciary Act of 1869. In the last year of the Obama administration, it was at 8. Justice Antonin Scalia had died, and that kind of got held up until Trump assumed office. And at first, just adding a couple side notes here, because of time, I'm not going to get much chance to do some of that as I'd like, but at first the Supreme Court was not a high statute post, or it didn't have a lot of high status to it. Sometimes the justices left the Supreme Court to take better jobs, to be quite honest about it. All these justices rode the circuit, meaning they had to literally ride horses around to hear court cases on appeal. And that was one of the pretexts for John Adams to look to pack the courts. They wanted to cut the circuit riding in half and add more justices. And Adams thought that was his chance to get some more Federalists in the on the bench. Some justices tallied up to about 10,000 miles a year on horseback, right? You see, kind of understand perhaps the sentiment of John Adams and some. Early Supreme Courts did decide some important cases. Let's take a look at one of those. The Marshall Court, Marbury versus Madison, and the concept of judicial review. John Adams, right? Partisan guy, probably, arguably, set a precedent for political parties, right? We looked at that last chapter. He appointed John Marshall, Federalist, thinking nationalist, Supreme Court Justice in 1801. Still considered the most important justice ever, John Marshall. He had a lot of reforms he instituted. One I'm going to mention is just a real broad interpretation of the necessary and proper clause that we've dwelt on, and the supremacy of the national government. Okay? So looking at your fills here, judicial review. Judicial review is the power to decide if a law or other legal issue contravenes the Constitution and overturn it. So this power is not mentioned in the Constitution. The Marshall Court established the power of judicial review for itself and posterity in Marbury versus Madison of 1803. Marbury versus Madison. Marbury's long-term effect has been to give additional powers to the court and allow them to determine what the Constitution means. I mean, in that particular case there, the court, basically said, it was not nice for Jefferson and Madison not to deliver, those certificates, but Adams was tacking on additional things to the Judiciary Act of 1789, which was unconstitutional. Let's take a look at the American legal system. The American legal system is a dual system. It's a dual system. And break this down. And go to the whiteboard. So you have state courts, and there's 50 of them, 50 different systems. Then you have your federal courts. Now both systems have 3 tiers. Trial courts, litigation begins, and the courts hear the facts of a case at hand. This is original jurisdiction. Appellate courts, they decide questions of law, not facts. This is called appellate jurisdiction. Then you have your high or supreme courts. Now, for you visual types, again, I always say this because I know it's helpful to many. On page 498, figure 14.2 is a really nice visual of this breakdown, right? I would encourage you to jot that down, and when you get a chance and you're studying, check that out. Turn next to jurisdiction. Before a court can hear a case, it must have jurisdiction, or the right to hear that particular case. And there are two basic types of jurisdiction: original jurisdiction and appellate jurisdiction. Original and appellate, right? Kind of been touching on that here early on. So original jurisdiction, again, is a court's authority to hear disputes and determine the facts of a case. Appellate jurisdiction is the power to review or revise a lower court's decision. The U.S. Supreme Court has both types of jurisdiction. About 6% of its caseload, the U.S. Supreme Court, consists of original jurisdiction cases. And these cases, I thought this was important to include this in here. What constitutes original jurisdiction for the U.S. Supreme Court, what will get their antennas up. And cases that involve two or more states, the United States and another state, foreign ambassadors or diplomats, or a state and a citizen of another state. About 94%, just doing your math there, about 94% of the U.S. Supreme Court's cases come to it through the appeals process and have already been heard by the highest state court, the U.S. Court of Appeals, perhaps maybe a court of military appeals, some lower federal courts, U.S. regulatory commissions, or legislative courts. It's already gone through those processes. All of them, some of them. Now we hear a lot about criminal and civil law. Criminal law regulates individual conduct. Laws, either state or national, determine what is legal and illegal. For example, prostitution and gambling are illegal in many places, but they're legal in other places. Also, punishments can differ dramatically from place to place. For murder, some states have the death penalty, right? And others don't. Since crimes are considered to be against society, the government is usually the plaintiff in criminal cases. Hence, titles like the people of the state of California versus Michael Jackson. Now, most crimes are state issues, though some, like kidnapping or bank robbery, are considered national/federal crimes. National/federal crimes. Civil law, on the other hand, civil law is about relations between private citizens, and that can include corporate citizens. So usually, civil lawsuits are about recovering damages of some kind and have both a plaintiff and a defendant. Most cases never get to court. Most civil disputes are settled out of court. So most never get to court. Most civil disputes are settled out of court, and criminal cases can settle due to plea bargains. They can settle due to plea bargains or dismissals. The federal court systems, take a look at that. The district courts, Federal courts of original jurisdiction are called district courts. There are 94 district courts with over 678 active judges and an additional 300 retired judges who assist by hearing cases on a limited basis. Now, every state has at least one district court, and these courts do not cross state lines. The largest states, California, New York, and Texas, each have 4 district courts. And again, your textbook has a nice graphic of this on page 499, figure 14.3, right? Page 499, figure 14.3. Now, just a side note, a couple side notes here about this. The bulk of the workload of federal courts occurs in district courts. It's about 325,000 cases. Each federal district has a U.S. attorney who's nominated by the president and confirmed by the Senate. He or she is the chief law enforcement officer for that district. The Court of Appeals. The Court of Appeals, the United States Court of Appeals, formerly known as the Circuit Court of Appeals, and I'm looking back at the fills here, is the intermediate appellate courts in the federal system. And there are 11. There are 11 circuit courts referred to by the number, plus the D.C. Court of Appeals, and then you have the U.S. Court of Appeals for the federal circuit. So you tally all that up and you have a total of 13 courts. The D.C. Court of Appeals deals with federal regulatory commissions and agencies, and the Federal Circuit Court deals with patents, contracts, financial claims against the federal government. Now, the courts of appeals have no original jurisdiction. In fact, a litigant does not have an automatic right of appeal. Most cases do not go any further than the district court, and those cases that go to the courts of appeals rarely go further. Courts of appeals try to correct errors of law and procedures. And again, it's not original jurisdiction. They don't hear new testimony, original testimony or any new testimony. So the decisions made by the courts of appeals are they're binding. They're binding on the district courts within their geographic territory. And only the U.S. Supreme Court sets national precedents. Precedents are extremely important in our legal system based on common law. The doctrine of stare decisis. The doctrine of stare decisis is the key to our system. And basically what it means is let the decision stand in Latin. This means judges rely on case law, past decisions, to shape their opinions, which leads to continuity, the logic goes, and predictability in the legal system. Stare decisis is basically recognizing those precedents. Constitution, just a couple FYIs here about this, doesn't set how many justices should serve. One justice is nominated by the president to be the Chief Justice. The other justices are known as associate justices. The Chief Justice, John Roberts, today, right? John Roberts presides over public sessions of the court. He conducts the court's conferences, assigns the writing of opinions, if he's in the majority. Otherwise, the senior justice in the majority will assign the opinions. By custom, the Chief Justice administers the oath of office to incoming presidents and vice presidents at the inauguration. Supreme Court, compared to others, has a very small staff, around 400 people and clerks. They hear roughly about 75 to 90 cases per term. How are they selected? Selecting of judges, very political process, unfortunately. Nominated by the president, confirmed by the Senate. Suggestions from members of the House of Representatives, senators, their political party, and others. In general, presidents try to select well-qualified individuals. They also use judicial appointments to advance their own political philosophies. The process has been getting more confrontational since the 80s. I remember in 1987, I think, was the precedent setter for that, a very brutal confirmation of Justice Robert Bork. Got very personal, as did Justice Kavanaugh, summer of, 2018, 19, right? You guys remember that one. And who are the federal judges? Typically, federal judges have held previous political office, such as a prosecutor or state court judge. Political experience, such as running a campaign. Of course, prior judicial experience. Lawyers, right? They've been lawyers. And then you have your appointments to the U.S. Supreme Court. Because of time, we won't go over that. Nomination criteria, you got to be competent. Usually ideologically aligned with the president. However, that hasn't always funneled out as such. Nixon, conservative Republican Nixon, nominated Warren Burger, thinking he was highly conservative, and he ended up becoming Chief Justice on one of the most activist courts in history. Then you had the Supreme Court confirmation process before 1900. 25% of presidential nominees to the Supreme Court were rejected by the Senate. The investigation process, the names are sent to the FBI before a nomination is formally made before vetting. And then the president also sends a list to the American Bar Association, the ABA, who rates the nominees. Right, and that's also a controversial process as well. That gets sent back to the Senate, Judiciary committees, and, then you have your lobbyists and your interest groups get involved in Senate committee hearings and Senate vote. Supreme Court today, 9,600 cases came into the Supreme Court recently, I should say, 2005-2006 term. The court held arguments on 90 cases. They signed opinions on 88 of them. The court has control over its own docket. Court decides what cases to hear. It hears from 2 to 5 original cases a year, not many, right? The rest are appellate, right? 94% of what they look at is appellate review. Then you have the petitions that go to the Chief Justice's office, the role of clerks. And then looking at the fills here, something I want you guys to know for the upcoming quiz. How does a case survive the process? How does a case survive the process? Well, it's difficult to guess why certain cases are heard. It's difficult to guess why certain cases are heard and others are not. And since the court doesn't announce its reasoning, we basically have to guess, right? So in general, cases that tend to be accepted share the following characteristics. Let me show you what they are. Back up here. The federal government asks for the review. The The federal government asks for the review. Could be some conflicts among the circuit courts on an issue. Some kind of civil rights or civil liberties question. Some kind of ideological or policy preference of the justices. Some kind of significant political or social interest. Hearing and deciding a case, once accepted, you have oral arguments. Looking at the fills here, oral arguments. Supreme Court terms begins the first Monday in October, and it runs through June or July. Oral arguments are generally scheduled from October through April at the beginning of a week, Monday through Wednesday. Each attorney gets 30 minutes, but is constantly interrupted from the bench with questions or comments. If you're like me and you don't have a life sometimes, you watch C-SPAN and you can hear some of these cases, and they're really tough to follow because of that. Oral arguments are an opportunity for the public to watch the court, right? To watch the court. The arguments also ensure that justices hear the most important facts and arguments in a case. They provide the justices with additional information, including the broad political implications of a decision. And the justices can highlight issues for each other through the process. Then they conference and then the vote, right? The justices meet on Fridays for closed conferences. Justices present their ideas in the order of seniority. And a vote is taken to see how each justice thinks he or she will vote. Conference votes are not the final, but as I say here, they're indicative of positions prior to the writing of an opinion. And the Chief Justice tends to be very important in these conferences. Writing opinions, opinion writing serves a number of functions. First, it's an opportunity for the justices to discuss their ideas in writing. Second, the process is a cumulative one, in which the point of each successive draft is to build a consensus or marshal a majority. So the drafting process leads to many iterations, much discussion, and the changing of minds of the courts. And there are 5 kinds of opinions. You have your majority opinion, right? Majority opinion reflects the ideas of the majority of the court. 5, 4, 6, 3, 7, 2, and so on. Stronger majorities mean stronger precedents. Concurring opinions. Concurring opinions. This is where a justice agrees with the verdict, but not the reasoning. Then you have your plurality opinion. Plurality opinion. 3 or 4 justices sign an opinion. Often these are on the winning side, accompanied by concurring opinions. Then you have your dissenting opinions. 1 or more justices disagrees with the opinions of the majority or plurality. And then you have your per curiam opinion. Your per curiam opinion, that's an unsigned opinion by the court. Now, if the Chief Justice is in the majority, he assigns the writing of the opinion. Otherwise, the senior justice in the majority assigns the opinion. Drafting an opinion is important and it allows justices to have a huge impact on how issues are framed and decided. Judicial restraint versus judicial activism. The former, judicial restraint, advocates minimalist roles. Strict construction. Strict construction. So, strict construction for the unelected court system. Now, the latter, judicial activism, feels that justices should use the law to promote justice, equality, and personal liberty. What we call judicial activism. Judicial activism. So, the court decisions always refer to previous legal decisions. Ours is a system of precedents and stare decisis. So it's often difficult to overturn a bad precedent, but it does happen. So just kind of wrapping up where we were today, if you have your graphic organizer. Today we looked at the roots of the judiciary, Article 3. Congress established lower courts. Article 3, judicial power to the courts, life tenure, permanent compensation. Least dangerous branch, right, to Alexander Hamilton. They cannot force compliance with their rulings. The Supreme Court has some original jurisdiction, as do district courts. Congress established the lower courts through the Judiciary Act of 1789. You have district courts, circuit courts of appeals, and then you have your highest court, the Supreme Court. Judicial review, we talked about that. That's where the courts can overturn laws and legal issues. The American legal system, state courts and federal courts, right? With both, you have trial courts, appellate courts, and a Supreme Court. There's original jurisdiction, and where litigation begins with the facts. Appellate courts, they review earlier decisions. American legal system also has jurisdiction, original jurisdiction. You hear disputes, determine the facts of a case. Appellate jurisdiction, review, revise a lower court's decision, and you have the right to hear a case with original jurisdiction. Supreme Court deals with both. 6% of the time it's original jurisdiction, 94% of the time appellate jurisdiction. The judiciary deals with law, criminal, civil law. Criminal law, individual conduct. The government is the plaintiff. Usually state issues, but occasionally federal crimes, usually settled by plea bargains or dismissals. Civil law deals with relations between private and corporate citizens. It's about recovery and damages, usually settled out of court. Then you have your federal court system we talked about. District courts. They hear original jurisdiction, the facts, and then above them, original. Then you have your 90. Let me back up. 94 district courts, and they don't cross state lines. The courts of appeals. These are your circuit courts. There are 13 of them. They are appellate courts, and they correct errors of laws and procedure of the lower courts. Then your Supreme Court, right? Your final arbiter. They hear cases from the lower courts. And then the Supreme Court today. Cases heard are not many. Most have certain characteristics. Hearing and deciding a case through oral arguments, conferences and votes, writing opinions with a goal to build consensus, and then the types of opinions. Majority opinions, concurring opinions, agreeing with the verdict but not the reasoning, plurality opinion, winning side, mixture of concurring opinions. You have your dissenting opinion, per curiam, right? Per curiam, an unsigned opinion. Judicial philosophy and decision-making, judicial restraint, strict constructionism, read the Constitution as believed to have been written, and then you have judicial activism, the use of courts to promote justice, equality, and personal liberty. You have your summing up sheets to go along with this, and tomorrow sometime I will have marching orders on some practice material. Okay, you guys are getting to know the drill now. If you have questions, feel free to get them to me, and I'll get back to you as soon as I can. Until next time, you guys take care, and please do stay well. Goodbye.